Ladies and gentlemen, thank you very much for coming to UCL and the Gustav Tuck Lecture Theatre. My name is Philippe Sands. I'm Professor of Law here at UCL. I've been asked to stand in for my Dean, Dame Hazel Gain, who unfortunately is not able to be here this evening, but sends her warm greetings to all of you and, of course, to Dr. O'Keefe and Professor O'Keefe. This is one of those wonderful rites of passage for this university and for every university. It is a joyous occasion for all of us here. We are here to celebrate Roger and his rite of passage at University College London. It's also, as a tradition at UCL, an opportunity for a new professor, in this case of law, to inform a wider audience about their field of expertise and the program of research in which they are engaged. It's for me a particular pleasure to introduce Roger because I've known him for many years, and I know that Roger knows something about the law and Roger knows something about life, and I'm sure tonight we are going to hear on both aspects. I have no idea what he is going to talk about. But I know Roger well enough to know it's going to be fabulous and it's going to be very interesting and probably slightly unexpected. So I'm hugely looking forward to hearing this lecture. But my real job is to introduce my dear friend and colleague, His Excellency, as I now have to get used to calling him, Judge James Crawford. Formerly the Hewell Professor of International Law at Cambridge, recently elected to the International Court of Justice. We await his first judgments with eager anticipation, as I'm sure he does too. James is someone who is very well known to many of you here. James was a colleague and a very close colleague of Roger's for many years. There is a relationship of mutual and wonderful respect between the two. They represent what is in effect the Australian takeover of international law in the United Kingdom, and that is a very, very wonderful thing. It is the opening up of international law, the transformation of international law that was occasioned by James's arrival on these shores about 25 years ago, and he's still very much part of it. Without further ado, to introduce Professor Roger O'Keefe, I'm very delighted to invite His Excellency Judge James Crawford to take the floor.
Thank you, Professor Sands. Professor O'Keefe, because although you haven't given your inaugural lecture yet, you are deemed to be inaugurated. Ladies and gentlemen, it's a great joy to watch a young man or woman, in this case man, come to your institution, show excellence, get appointed. I remember I wasn't on the appointments committee when he was appointed at Cambridge. I remember walking around nervously outside, wondering whether his Australianness would stand against him. And then see him develop in all sorts of ways. Work with him, teach with him, watch his publications come out, his first book on cultural property, his later work, see him develop in his own way, and then see him take up one of the primary chairs of international law in the United Kingdom. I've seen all of that through Roger for the last 20 years, and as I say, it's been a joy. But thinking about Roger, it's difficult to find the right adjectives. I thought of general international lawyer, but although he teaches humanitarian law, he doesn't look anything like a general. I thought of serious international lawyer. The word serious sometimes doesn't fit Roger. He gave an absolutely brilliant talk at the European Society of International Law Conference in Cambridge, which has become epic. in its retelling. And it had everyone laughing for the entire 60 minutes. But I won't predict that he'll do that today. He'll satisfy his own ways of doing these things. I think of him as mainstream. But he's not entirely mainstream because he spreads out in a range of ways. And I think of him as Australian. And he is Australian. His genetic heritage in Australia includes both a very senior judge and an extremely popular pop musician. I think that helps to explain Roger in various ways. And yet he is each of those things at the same time. He is a general international lawyer. He doesn't set up specialities and work within them. He looks at the whole subject, and often in ways that are profound. He's a serious international lawyer, as anyone will know who's read his work. His wonderful piece on incorporation in the British Yearbook shattered the old myths of that subject. I don't say it created new myths, but it looked at the situation very much in an original way. He's mainstream in that he looks at international law as a very capable technician, but who's someone beyond that, someone who looks at the subject in relation to the rest of the subject matter that we study. And he's certainly Australian. I don't take any credit for the numbers of Australians, some of whom are in this audience, who've come to England in the last 20 years, none whatever. It's simply a function of the openness of this intellectual community in the United Kingdom to people from all sorts of countries. And it's just that Australians have tended to follow each other. The other thing is he's inspirational. He's an absolutely wonderful teacher, both at the undergraduate and graduate level. And he's inspired his own generations of students and will continue to do so. University College is lucky to have him. Roger.
Pacta virumque cano. A long time ago, in a hemisphere far, far away, was born a man by the grandiloquently improbable name of Dionisio Hans Georg Salamander. Reared in a home girt by sea and seared by summer infernos, he was a creature of both water and fire. As a boy, he enjoyed endless days at the beach and, as something of a juvenile versifier, endless nights in the embrace of Calliope, Euterpe, Erato, or Thalia, depending on which was free and could bear to spend a warm summer's evening humouring an underage wordsmith. Young Dionisio Hans Georg did well at school, and after what could only be called a modicum of tertiary educational peripatesis, his grown self settled on a career as an international lawyer. Well, it could only be called that by a lawyer. More precisely, H.G. Salamander settled on a career as an academic international lawyer. Scoffed a city solicitor friend, informed one drunken night of Salamander's vocation. Those that can, do. Those that can't, teach. Ho ho, replied Salamander sarcastically. Those that can, do. Those that can't, solicit. Absurdly early next morning, nursing a hangover, a cut lower lip, and the forlorn wish that his jeu de mots had been by way of l'esprit de l'escalier, Salamander was up and at 'em, slaving over a manuscript to the inexorable deadline of some unrelenting editorial fury. Absurdly early. Inexorable. L'esprit de l'escalier. Lo spirito, der Geist, der Volksgeist, der Rechtsgeist, l'esprit des lois, la solidarité sociale, le dédoublement fonctionnel, voiceless labiodental fricative on cut lower lip, la compétence de la compétence, forlorn. Forlorn. The very word was like a bell to toll him back from the sibilant fricative of Article 36.6 of the Statute of the International Court of Justice to his sole self. And soul was the word. No, just soul. It was a solitary calling. Eunomia was a demanding mistress, to mix metaphors. In terms of the legal philosophy to which he subscribed, H.G. Salamander was a positivist. Given the practical difficulty in a world of sometimes radical, moral and political pluralism of ascertaining from reason an objective notion of the good, he believed that the intersubjective approximation of the latter, derivable directly or at one adjudicatory remove, from the premise that international law was what states, through their governments as the representatives of their peoples, agreed it to be, was the most legitimate and prudent basis for an international legal order. This was not to say that Salamander was ideologically wedded to the privileged position of states within the international legal order of his day. International legal positivism, to his way of seeing things, had nothing inherently to do with states. What legal positivism meant was simply that the law was whatever an authorised temporal lawmaker validly said it was, or posited, as in laid down, instead of being wholly deducible from certain first principles or divinely ordained. And in the international legal system as it then stood, it just so happened that the authorised temporal lawmakers were first and foremost states. If these states were to agree the following morning, preferably not absurdly early, that international law was whatever a global legislature of everyday individuals or a troika of sage, prophet and poet deemed it to be, international law would remain a positivist legal system, but one in which states no longer played a formal role in lawmaking. Anyway, the essence of positivism, it seemed to Salamander, was an adherence to what is, rather than to what a priori principle says should be. And it was an observable fact that states had acquiesced in at least the loosening of their monopoly on international lawmaking, conceding some role to international organisations and, to all intents and purposes, to international courts and tribunals. Moreover, to say that international law was what states posited it to be was to enunciate no more than the formal juridical position. It was not to deny the existence of a much larger heterogeneous cast of actors who, in the real world of political and other social contestation, influenced the international lawmaking policy of governments and, through them, of the legal constructs that international law called states. Having reproduced the foregoing apologia pro vita sua in half a dozen applications for a chair, Salamander had it down to an ars finis. No, ars. As it was, Salamander had always struggled to see what was inherently wrong with states, as the term was used in international law. A state, within the meaning of international law, was no more than a legal person, a juridical construct, a formal juristic concept, abstracted from political and other social reality, even if it was mapped onto that reality. In the words of the immortal Austrian, the state, for the purposes of international law, was not a biological, psychological or sociological unit. It was a specifically juristic unit, the personification of a social order. constituting the community we call state. As far as Salamander could tell, the story went something like this. In the beginning, God created the heavens and the earth. Fast forwarding a few frames, God said, "Let the water under the sky be gathered to one place and let dry ground appear." And it was so. He or she, the jury was still out, called the dry ground land, and the gathered waters he or she called seas. Saw that it was good, had a breather, did a bit more work, had another breather, created man in his own image, male and female he created them, giving us a hint as to the gender question. The serpent appeared, the apple got ate, the happy couple were cast out, they were now less happy, if more knowledgeable. They threw on some clothes, were fruitful and multiplied, probably not in that order. And their descendants, as many as the stars in heaven and the grains of sand on the seashore, arranged themselves in orderly fashion, albeit maybe with a smidgen of terminological, not to mention earthly and celestial overlap, into thrones, dominions, principalities, and powers. In the alternative, speeding up proceedings somewhat, there was a whopping great but oxymoronically silent bang, primordial slime, mitochondrial DNA, apes, aquatic or otherwise, a square-jawed lass called Lucy, Homo erectus, a brief period of censorship, Homo sapiens, who, like the unhappy couple, was knowledgeable, Homo sapiens sapiens, even more so, and eventually the aforementioned arrangement into thrones, dominions, principalities, and powers. Now, some of these TDPPs were good, some bad, some happy, some sad. Some monarchical, some republican, some national, some multinational, some unitary, some federal, some democratic, some depends on what you mean by democracy. Some secular, some theocratic, although the amount God rested cast doubt on his fitness for office. Regardless, however, or perhaps on account of their many and varied contingent qualities, these TDPPs, having no common judge but needing legal rules among them, duly acknowledged the existence of an inter-TDPP law, in which the fundamental juridical unit was, no prizes for guessing, the TDPP, good or bad, happy or sad, a unit which came to be referred to variously as civitas, res publica, gens, the more personalised princeps or souverain, and eventually, in a drive for terminological standardisation, the state. In this light, the standard critique of the state-centrism of this interstate, or courtesy of the auto-iconic Mr. Bentham, international law, was, to Salamander's mind, misdirected. The problem was not that the legal community we call state was the radical site of international law. The problem was some of the social orders of which the state was the legal personification. States as such were not the issue. Bad governments or systems of government were. There were plenty of bad apples, but no one blamed the apple. Anyway, had not these self-same states voluntarily fettered their government's freedom of repression through international human rights law, including minority rights and the rights of indigenous peoples, the law of non-international armed conflict and like international legal goods? Furthermore, could an international lawyer not conceive of the state in favourable terms as the juridical vehicle through which a people, in the sense of the entire population of a state, exercised its right to self-determination? Was the state sovereign and equal with others, not simply the formal international legal guise in which the people clothed in it, without prejudice to the existence and rights of any peoples forming a subset of that people, freely determined its political status and freely pursued its economic, social, and cultural development, in the words of the two international covenants. All of this looked to Salamander like the road to human flourishing, not perdition. As one may have guessed, D.H.G. Salamander was also a legal formalist, what some would call a black letter lawyer, which was certainly more promising than a dead letter lawyer, but less arousing than his or her French counterparts. He adhered to the orthodox methodological disciplines of international law, looking for answers to international legal questions within the international legal system itself, identifying, interpreting, and applying the positive law by way of a strict application of the system's framework rules and concepts and its general canons of legal reasoning. To his perhaps simplistic way of seeing things, legitimacy compelled the faithful giving effect to the rules of the game settled on by the game's recognised rulemakers. Conversely, he viewed at least a certain brand of anti-formalism as the Trojan horse or useful innocent of hegemony, whether geopolitical, institutional, or personal. At a more fundamental level, truth compelled fidelity to the logic of the thing. And Salamander had a thing for truth. Salamander was not deaf to or uninterested in the instrumental potential of international law, scrupulously practiced as a means of emancipation, but by temperament he cleaved to a modest vision of the role of the international legal academic in such things, holding a sanguine estimation of his own likely influence on the international legal order. As for international law's geopolitical, politico-philosophical, moral philosophical, and socio-cultural contexts and influences, past and present, Salamander saw these as worthy and fascinating objects of inquiry in their own right. He valued, too, the insights of legal philosophy, linguistics, and hermeneutics, while applauding the empirical turn in international legal scholarship. Nor was he hostile to critical theoretical approaches, which played their salutary subversive role in an ecumenical college as a kind of loyal opposition, even if, again, by temperament, which included his semantic hypersensitivity, he himself preferred not to problematize things, but to make them as simple as possible, though no simpler. Old school natural law also had its place, provided it was invoked in mindfulness of its particular intellectual heritage and as no more than a critical standard against which to measure the desirability of a positive rule, rather than to deny that rule's formal applicability. In all things academic, Salamander's sole yardstick was a good argument. If truth be told, moreover, alongside the good arguments of these other schools, he could feel inadequate, a journeyman, a trundling medium pacer in the midst of their fast, fierce bouncers or fizzing flippers and googlies. No, H.G. Salamander's bugbears roamed elsewhere. Salamander took issue with academic international lawyers, and even more so judges, who claimed that the resolution of this or that international legal question was not what a faithful adherence to the rules of the game suggested, but what their partial account of the values purportedly reflected in the law was said to suggest. In Salamander's view, this essentially populist opposition of positive law and the values underlying it between mere black letter law and some more authentic spirit of that law was spurious. The positive law was the values, or at least a particular formal embodiment of those values. This being so, recourse, in preference, in effect, to the application of the positive law to what was said to be the values underpinning it was misconceived at best and special pleading at worst. Moreover, positive rules of international law, whether posited directly by states or created by the judicial application of higher order positive rules, were typically the embodiment not of unalloyed values, but of a pinchbeck, compromise sort of value, in the assay of which by some international lawyers there was a predictable tendency to neglect the base metals. None of this meant that an international lawyer was not to apply those established rules of treaty interpretation which looked to the gist of a provision, reading the text in the treaties in the light of the treaty's object and purpose, considering the rationale for the provision in accordance with the uncodified maxim ut res magis valeat quam pereat, even cautious recourse to the perilous travaux preparatoires. These rules of interpretation were part of the rules of the game. Moreover, they related to ascertaining the content of the positive law in the first place, not to effectively displacing the application of that law in favour of its purported raison d'être. Nor did international legal formalism leave no place for the teleological application of policy infra legem, provided that this was genuinely infra legem, and that the policy appealed to was manifestly privileged by the regime of international law in question, by the general body of international law, or by general canons of legal reasoning. Even less so did a formalist approach to international law exclude the application in appropriate international cases, as permitted again by the rules of the game themselves, of those elementary principles of equity common to the world's legal traditions. As for those academics and judges who would substitute for the unswerving application of a rule of positive law policy considerations wholly extraneous to it, they were beyond the pale. This was the job not of the lawyer, but of the legislator, who, as it was, displaced the applicable rule of positive law not with values as such, but with the embodiment of those values in the specific form of a new rule of positive law. Only slightly less far up his nose got those academic international lawyers and judges who, while paying lip service to the rules of the game, played fast and loose with them in pursuit of a priori commitments, overt or covert. He acknowledged that complete divestment of the jurist's ego was impossible, but this banal insight did not mean that the jurist could not strive for an account of the positive law that was as objective as humanly possible. Nor was he fool enough to think that the answers arrived at by applying the rules of the game were in every instance clear. Indeed, anything but. The legal system provided for by these rules was as much inductive as deductive. Its functioning was heavily dependent on the blurred calibration of factual and legal factual appreciation. Competing rules were often in play, and so on. It was not an exact science. Pace, the immortal Austrian, it was not really a science at all. In short, there were always hard cases, points on which reasonable people could differ, with predicted outcomes per force stated in terms only of probabilities. But this was not the same as radical indeterminacy. The convincing existed when the compelling did not. There existed in each case a penumbra of reasonableness, a finely enough calibrated intersubjective standard, a generally shared sense of where the line was to be drawn, beyond which an answer reached by the purported application of the rules could be said to be wrong. Now, simple muddle-headedness was excusable. Everyone made mistakes. Understandable too was legal advocacy by legal advocates. It was the job of counsel in litigious proceedings to spin the law in the way most favourable to their client, even if there still ought to be self-restraint, a self-policing adherence to some sort of internal discipline in the higher interest of what, by no coincidence, was called the discipline. The same, mutatis mutandis, could be said on both counts of legal officers of campaigning NGOs. Their job, within limits, was to campaign. There was even nothing wrong with international legal academics speaking and writing explicitly de lege ferenda in declared reformist mode. Nope, the kick of Salamander's hobby horse was reserved for those international legal academics and judges who disingenuinely passed off policy as lex lata. In H.G. Salamander's eyes, these three exasperating types, which in essence were one and the same, willfully, knowingly, and unacceptably bent the agreed rules. In the pungent words of the Faustian German, quoting an imprudent Frenchman, they wanted to cheat. They sought to exempt themselves from the ineluctable distinction between is and ought, on which positivist international law, the international legal system as it had functioned since the temporal eclipse of natural law, was founded. And the scorn that not a few of them poured in the process on the formalist positivism of this agreed system riled Salamander. So it was with a dark, delicious pleasure that he was wont to quote that true bearer of light from University College London, the sceptical, quixotic German, who wrote all those years ago in Current Legal Problems, "International lawyers are prone to suffer from a professional disease against which other members of the legal profession are remarkably immune. The reasons for this idiosyncrasy are not far to seek: the inherent weakness of international law in an overriding system of power politics, an understandable temptation to hide this state of affairs from oneself and others by means of elaborate images, and a revivalist movement towards a new naturalism which lacks so conspicuously the innocence of mind of the early naturalists, all bear their measured share in producing the phenomenon of the evangelist international lawyer." And by no means were the evangelists to be found only among the fluffy bunnies. The hawks too had their unhealthy share of proselytizing ideologues. But what drew H.G. Salamander to a formalist vision of international law went beyond the jurisprudential. International legal formalism provided an outlet for what Salamander cared to think of as his aesthetic sensibility. There was a Vitruvian beauty in the systematic logic of international law's formal reasoning, a venustas to complement the disciplines firmitas and utilitas. Things had their pleasing place. Salamander felt called to maintain and even refine this attractive intellectual architecture. Salamander revelled too in the play of formal international legal reasoning, relishing what the jocular German saw as the characteristic lightness and sense of relief we find in playing, and the energeia with its telos within itself that was the being of all play. It was no coincidence that Salamander referred to the normative framework of the international legal system as the rules of the game. By this, he did not intend that international law was mere recreation, idle amusement, a parlour game like a round of charades, even if there were shades of musical chairs when it came to the big professorships. In the further words of the merry Marburger, play contained its own, even sacred, seriousness. What Salamander meant, borrowing again from the humorous Hessian, was that international legal reasoning comprised a closed universe in which the purposive relations of ordinary human existence were curiously suspended. It was a mutually agreed imaginary world with its own proper spirit, where the player's conduct was tied to the make-believe goals of the game rather than to the world of aims, where that player experienced the game as a reality surpassing him or her, and where the player's actions should not be considered subjective actions, since it was rather the game itself that played, drawing the players into itself and itself becoming the subjectum of the playing. International legal reasoning, in other words, was its own measure, transcending the question whether it was real, because a superior truth spoke from it, a truth that was properly neither believed nor not believed outside the play situation, the truth of play, the truth of the logic of the thing. In this way, a formalist vision of international law appealed not only to the homo ludens in Salamander, who, with Chesterton, believed that the true object of all human life was play, but also to the seeker in him of what was true. Salamander also found communion in the universe of formal international legal reasoning. He felt himself, perhaps quaintly, part of a tradition spanning generations and continents, a tradition which was always different, always new, whose historical life depended on being constantly assimilated and interpreted. In this living canon, he ceased to feel alone. Indeed, in the internalization, actualization, and revitalization of this common dogmatic and hermeneutic heritage, Salamander lost sense of the dancer for the dance, or dancer for the dance. Let's call the whole thing out. In these various senses, international legal formalism felt to Salamander like the sea, with its shapely beauty, its resting absolutely within itself, its oneness over time and space. It was perhaps no coincidence that the law of the sea occupied a central place in the history of the... Actually, it was complete coincidence. What a load of bollocks. Thank God for delete, he reflected, relieved. In addition, Salamander relished the craft of black letter international lawyering. The international lawyer, like the sawyer and the bowyer, was the exponent of a skill and know-how gained by apprenticeship, honed by experience, and wondrous to behold in the hands of a master. The business of international law rested on a seasoned judgment and what a London cabbie would call the knowledge, on a kind of tact and a well-stocked memory, to quote once more the Teutonic tickler Pink. This practical aspect appealed to the homo faber in Salamander, who, like your typical bourgeois professional, sometimes yearned for the more grounded life of the cooper, the cordwainer, the mason, the shipwright, the organic winemaker, the artisan pâtissier, the acorn-fed porco iberico swineherd, or the virtuoso landscape architect, even if he lacked the capability. Shoddy workmanship irked him. Shysters even more so. Finally, Salamander viewed black letter international lawyering as a form of service. It involved, in the words of Heidelberg's high priest of hermeneutics and hilarity, subordinating oneself to the superior claim the rule made, placing oneself at the service of what was considered valid. And Salamander had a thing for service. But it was not all beauty, truth, and miscellaneous high-mindedness. The international legal system, while its own reality, was predicated on the external reality, the real reality, as it were, of the practice of states. It was ultimately positivist, and as an international legal positivist, H.G. Salamander was necessarily a down and dirty empiricist. And what down and dirty data, what incident and idiosyncrasy with which to work, All human life was there. The agony and the ecstasy, the tragedy and farce, the stuff and nonsense of international affairs, past and present, visibilium omnium et invisibilium. The human world, the bringer of plurabilities, its song be sung, its rill be run. Like the sea, it teemed with life. So too knew it death, the destroyer of worlds, Assyrian, wolf and fold, all kneeling before it and trembling. The Divine Comedy, the Encyclopedia Satanica, he sang the Corpus Eclectic. Out of this Dionysian frenzy, out of the fury and the mire of human veins, it was not only the distinctive service, but also a large part of the fun of the international lawyer, to discern and to elaborate with Ancelottian clarity and normative logic. As for whether at heart he was an international legal apologist or critic, Salamander took the view that he could rightly no more praise or condemn international law for justice or injustice than he could a language for a kind or hurtful word. There was no use indicting laws. They were no shoddier than what they peddled. Law, to quote again the immortal Austrian, was simply a specific social technique for the achievement of ends determined by politics. International law, as someone else would write somewhere, was no more than a vehicle for human values, a language of human self-ordering, a particular praxis of human willing. If the rules were warped, the blame lay with the crooked timber. Yet, for all her tender ministrations, Eunomia remained a demanding mistress. She also remained a demanding reed, or at least her namesake did. Although no one, the London cabbie, the troika or trinity of sage, prophet and poet, and least of all D.H.G. Salamander, minded too much. Yep, she was a demanding mistress, all right. So much to write, so little time, to borrow from Wonka. The job involved so much drudgery. Tomorrow and tomorrow and tomorrow crept in this petty pace from day to day. Yet here were his friends pumping out publications as if by colonic irrigation. The pugnacious Georgian, the feisty Serb, the neotenous Nigerian, the bouffanted Belgian. God damn it, did that well-coiffed Walloon never sleep? The productivity of these characters was demoralising. Just when you thought it was safe to go back in the water, out leapt another book, article, chapter or blog post by one of these men possessed. And men they all were, these Gatling guns of international legal scholarship. The legions of women womaning the academy, saner and more sapiens, seemed to stop to smell the roses. There was probably an article in there somewhere, but there was no bleeding time to write it. Salamander felt the urge to cry out, "Polacco, Polacco, doucement, festina bloody lente," and whatever the cognate injunction was in Georgian and Yoruba. But it would have been in vain. Professors Fangio, Gonzalez, Runner and Bolt were not about to take their respective feet off the gas. Their Stakhanovite output was unstoppable. Did these guys not have teaching, supervising, marking, summative and formative, external examining, pastoral and enabling duties? Did they not have admin coming out their ears, or out of what Joe Orton would have called their ears? References, student admissions, attendance monitoring, peer observation, peer appraisal, self-appraisal, time allocation surveys, fire safety induction, expense claims, faculty meetings, committee meetings, subcommittee meetings, workshops of every shape and size. Did they not have faculty away days? The teaching away day, the learning away day, the teaching and learning away day, the research away day, the research funding away day, the funding the research funding away day, the student satisfaction away day, the student dissatisfaction away day, the staff dissatisfaction away day, the staff suicide away day. The list went on. Sure, more often than not, Salamander interpreted the key word to mean that he would be away that day. But it was the thought that counted. To his friend's well-meaning inquiry, "What are you working on at the moment?" Honesty compelled the answer, half a dozen hypothetical scenarios on the Dangerous Dogs Act 1991 UK for the undergraduate client interviewing competition. Dignity, however, prompted an equivocal, but no less truthful, the usual. Where had fled his youthful disinvolta sprezzatura? What had spawned this pasticciaccio brutto? Who in Satan's name invented Moodle? How many goddamn emails could a human being get? It depressed him. Work, without so much as a sponge soaked in vinegar by way of mercy. Eloi, lama sabachthani! Oh God, oh Montreal! To top it all off, that Lusophone Latin American light of the international judicial world and universal legal conscience had just published his maximum opus. $1,876 pages. Jesus wept. Salamander had been forced to brush up his schoolboy Latin just to get through these epistles to the Philistines, although finishing them seemed merely to deepen his perplexity. Quousque tandem abutere Catalina patientia nostra. He could handle the primus. He could tolerate the secundus. He could even just about hold down the tertius after a big night out with his city solicitor friend. But whether out of excessive wetting of Occam's razor or simple eye fatigue, he was unable to suppress the suspicion that if an epilogue ever contained a quadragesimus quintus, something somewhere had gone horribly wrong. Words, a veritable cornucopia of words, the miracle of the loaves and footnotes. Full many a flower was born to blush unseen and waste its sweetness on the desert air. But not this rare specimen. Reading the stuff was like ploughing through the procès-verbaux of "I'm a celebrity, get me out of here." A whole series of it, with commentary by Augustine and Aquinas. True, in the beginning was the Word, but there was only one of them. Even leaving aside demanding mistresses, H.G. Salamander did not find it all plain sailing. For all his unrepentant formalist positivism, he harboured at times unsettling methodological, even existential doubts. To begin with, the rules of the game were to an extent fluid, neither immutable nor amendable solely at specified constitutional moments. Their ongoing ascertainment, like that of other rules of customary international law, rested ultimately on induction from the quizzicality and quiddity of human affairs. It was not always clear where hegemonic slates of hand and shoddy workmanship ended and novel processes of international lawmaking began, where rigorous adherence to the methodological disciplines of the international lawyer's craft flowed into fusty insistence on dépassé forms or harumphing reaction. At crucial moments, was he a vigilant custodian of the lux et popula sacra, or a blind defender of the Ancien Régime? When should he jump ship? The timing called for such keenly attuned, disinterested, and fearless exercise of the practical discernment of the international lawyer as now and then to make him queasy. This was not the sea of psychic refuge, but a dolphin-torn, a gong-tormented sea. It was maybe more enticing than a snot-green sea, a scrotum-tightening sea, but if so, only marginally. Exacerbating Salamander's episodic nausea, his commitment to a formalist, positivist international law was inescapably and discomfortingly a conservative preference. Granted, such an international law could be a vehicle of emancipation as much as of domination. Think of the right to self-determination. Think of international human rights law. All it took was agreement amongst states. But such a vision still reflected a plumping for the civility of form and process over the righteous overthrow of the tables of the money changers and the seats of them that sold doves. And he was never persuaded beyond doubt that the first was the better. It seemed undeniable that strict adherence to the rules of the game could leave unremedied, even ratify, injustice and suffering. It was all very well and good to blame the crooked timber, but what of the drowned child in the here and now? At times it was anguishing. Had not many of the great progressive developments of international law come about after a judge or scholar, with a fine disregard for the rules of the game as played at the time, picked up the ball and ran? You couldn't make an omelette without breaking a few eggs. What was so wrong with appealing to at least manifest underlying values in those rare circumstances where the positive law appeared so at odds with them, and where an intimation of justice, or of at least manifest injustice, cried out for it? Was intentionally and knowingly disguising lex ferenda as lex lata really a hanging offence? After all, judicial decisions and the teachings of the most highly qualified publicists, the latter term interpreted these days somewhat indulgently, were no more than subsidiary sources for the determination of rules of international law. If they failed to persuade states, states would take them at best cum grano salis. For every taditch, there was an ayash. Indeed, if they failed to persuade other judges and scholars, they would suffer a similar fate, or worse. For every taditch, there was an application of the Convention on the Prevention and Punishment of the Crime of Genocide waiting to trash it. All Salamander would be doing by pushing out the boat would be contributing to the debate, to mix metaphors. And why, for that matter, did he place himself alongside international judges? Judges decided actual cases, cases in which states had submitted to a court's jurisdiction on the implied understanding that the rules of the game would be scrupulously observed. Moreover, the fluid international legal game had begun to resemble a watered-down common law system in which courts actually made law, applicable beyond the parties to the dispute, making legitimacy all the more imperative in the judicial context. But international legal academics decided nothing, and the writings of the most, the least, and the fair to middling highly qualified publicists did not make international law. Was it not a little precious to insist that the ivory tower play by the rules? To mix more metaphors, most fundamentally and scrotum-tighteningly, what of the suspension of the purposive relations of ordinary human existence that was of the essence of a formalist vision of international law? Was this not a moral abdication? Was it not fiddling while Rome burned? And was it not ethically glib to believe that the actions of the players in the game, albeit the serious, even sacredly serious game of international legal reasoning, were not their own actions, but those of the game itself? This sounded frighteningly like just following orders. Everyone had the power to choose. In short, was there any sin in being an evangelist, academic, international lawyer? Was it damnable not to be? Yet, he could not bring himself to take that plunge. Free to dream, he might have dived right in, but his mind forged manacles, his perhaps over-susceptible aversion to what he intuited as untruth, held him back. So too did his temperament, although it was probably the same thing. Like Dr. Rieu, he would not let himself go where he ought not to. One had to stick with what one knew to describe what one had seen. Whether this was courage or its opposite, he was uncertain. But to act otherwise would have been a lie. He was not sure what was right, but he knew what felt dishonest. What an impossible fellow I am, he sighed with the whiskey priest, and how useless. The law is always deficient, wrote the jocular German, not because it is imperfect in itself, but because human reality is necessarily imperfect in comparison to the ordered world of law. To the Homo sapiens sapiens in Salamander, this rang true. He was not persuaded beyond doubt. His instinct felt truer than the alternative, but it was a defeasible truth. His conviction was provisional. His conviction also rested on a desperate hope. It was a hope that others might do better, if only fail better. Salamander drew a modicum of consolation from the thought that he was but part, a small, brief part, of a conversation, in the words of the late centenarian Spielmeister, that never ends, in which no word is the last word, just as there is no first word, in which every word is itself always an answer and gives rise always to a new question. In turn, the conversation that was international law was but a small part of a greater conversation. Salamander found some comfort in reminding himself that when all was said and done, it was only law. It was only a game, as it were. It did not foreclose the possibility of moral agency and attendant practical action in the world of social reality. It was only one specific technique among many for human self-ordering and, where desired, for the remedy of social ills. There were many times, in the words of the worldly wise Welshman, when it was much better to call upon a politician or a priest or a doctor or a plumber. And, indeed, the greater part of the task of setting the world to rights fell to the first of these, to that more important universe of human imagining and willing, to politics, which is to say that it fell to the human capacity to imagine a better world and to the strength of the human desire to bring it about. Here, Salamander's hope, his desperate hope, lay in the eventual world historical vindication of the human intolerance of injustice. A hope that was ultimately one and the same as his hope in the inevitable correction by the cosmic logos of unidiomatic usage. Perhaps best of all, Salamander's hope hinted to him that maybe he did not have to work quite so hard. Maybe while the pugnacious Georgian, the feisty Serb, the neotenous Nigerian, and the bouffanted Belgian burned the midnight oil, while the luciphone Latin American light of the international judicial world and universal legal conscience levelled whole rainforests in his zealous construction of a humanised international law, he, Dionysius, Hans Georg Salamander, could bunk off to the beach. Play up then, he thought to himself. Play up and play the game. The wistful, beautiful game. O jogo bonito, as his Augustinian excellency might have said. Embrace what the sceptical, quixotic German in his inaugural lecture at University College London called the misery and grandeur of international law. Practice your craft, the craft of the Guild of International Lawyers, present and past, but do so with a humility born of indefeasible doubt. Take to sea, the sea, but beware the murderous innocence of the sea. When tidying his office for the first time in 50 years, D.H.G. Salamander chanced upon a poem he had written in his youth. It went like this. When I grow up, I dream I'll be a sea otter, gorging my belly on poor-shucked abalone, effortlessly light and lounging on pillows of kelp. When I grow up, I fear I'll be a beaver, the worthy of the woods whose winter warmth is earned with summer days not spent, but banked. Yet, when I grow up, I bet I'll be a salamander, promising but never quite managing to live on dry land. Entertaining in a fashion, perhaps bizarre to some, but floating, unflinching. Of course, he became none of these things, at least not literally. He became an academic international lawyer. And in the fullness of time, he assumed the posts of Controller General of the integrity of the normative system, and on retirement, poet in residence at the European Journal of International Law. Seaside residence. During the aforementioned excavation of his office, D.H.G. Salamander also found an old photo. A photo whose message he felt apt for a legal field peculiarly prone to anxieties, discontents, crises, and the po-faced manufacture of mountains out of molehills. It tickled his fancy so much that he submitted it to the European Journal of International Law's roaming charges section, which, in keeping with the impeccable standards of editorial transparency for which the journal was famed, published it immediately. It looked like this. It was a call, albeit one expressed in the imperative mood rather than the hortative subjunctive, to which Salamander imagined that crafty old reformed playboy Augustine, Saint Augustine, the original one, would have responded with a single word: Amen.
So there's been another benign larrikin before him. Obviously taught him well. It was a wonderful exposure and expose of the angst of the profession by someone who has still much to say about the profession and many miles to go before he goes to the seaside.
Well, on behalf of Hazel Genn, the Dean of the Faculty of Laws, it's my great pleasure and privilege to formally inaugurate you, Roger O'Keefe, as Professor of Public International Law in the Faculty of Laws at University College London. Welcome.